Thank you, everyone, for joining us today. My name is Professor Paula O'Brien. I'm one of the directors of the Health Law and Ethics Network at Melbourne Law School. I'm very pleased to welcome everybody today, and especially our two speakers, our colleagues, Associate Professor Anna Arstein-Kerslake and Dr. Kay Wilson. And so we're coming together today for their presentation on human rights and disability systems, international and Australian perspectives. Before we start the seminar, I'd like to pay my respects to elders past, present and emerging, and acknowledge that Melbourne University, the Parkville campus, stands on the unceded lands of the Wurundjeri people of the Kulin Nation. I welcome Indigenous colleagues who are in the room or in the Zoom room today with us. So we're very pleased to have Anna and Kay with us today. They're both leading experts in the field of disability law, and today they're bringing together their different perspectives from their research, their different research streams on disability law. So the way we'll run today, if you haven't been to a Helen seminar before, we will have presentations by both of the speakers. So Kay will lead and go first, and then Anna will follow. And then we'll have about 15 minutes for open discussion, question and answer with everybody who's here. So thank you very much to both of you. And we'll let Kay share her slides to start the seminar today. Thanks, Kay.
Hello, everybody. I'm Dr. Kay Wilson, and I'm a postdoctoral translational research fellow at the Victorian Collaborative Centre for Mental Health and Wellbeing, a role I just started yesterday, and an honorary fellow with Melbourne Disability Institute, University of Melbourne. And I did the research for this paper that I'm presenting today when I was a Melbourne postdoctoral fellow at Melbourne Law School. And it's based on, in part, funded by a research excellence grant. And I presented it at the AABHL conference in Sydney in December last year. But I have a bit more time to go into it in this today. So today's going to talk about the Australian perspective, and Anna's going to talk about the international perspective. And the focus of this talk is what do the Royal Commissions into mental health, disability and aged care mean for the future of social support and the human rights of vulnerable Australians. And I sort of came up with this as a research topic when it struck me that we'd had three major, perhaps once in a generation, Royal Commissions on mental health, disability and aged care within about 5 years. And I guess I was sort of thinking, wow, what does that mean? What's going on with mental health, disability and aged care? And what we might call, and what I argue is that, because we don't always think about them together, as an overarching sort of care and support sector. So I'd like to begin with the acknowledgement of country. So I'd like to acknowledge the Wurundjeri peoples of the Kulin Nations as traditional owners of the land on which the seminar is held, and to pay our respects to their elders past, present and emerging. And as Paula said, anyone who is joining us today. So this is a brief roadmap of the presentation. I'm just going to start with a brief overview of the Mental Health, Aged Care and Disability Commissions for anyone who really isn't that familiar with them, because I think you need to have a bit of a background about their terms of reference and methodology to be able to compare them meaningfully and to understand where they're coming from. Then I'm going to just talk briefly about the 7 common themes that I just found recurring across reports. I found there was a lot of commonality and even sometimes common language in the issues that were found in the 3 sectors. But I don't have time to go into all 7 today, unfortunately. That would take a much longer presentation. So I thought I would just pick 2 and focus on those. So the first one's negative social attitudes and discrimination and what that means in each sector. And also, really looking at the pointy end of restrictive practices. And then I thought I'd finish with a brief comment on the response of the government to the Royal Commissions so far. So the Mental Health Commission is a bit different from the other commissions because it was a Victorian commission, so it's just in relation to Victoria. But I think the findings probably are relevant well beyond Victoria. So it went from the 22nd of February 2019 to the 5th of February 2021, and all the Royal Commissions had COVID basically happening in the middle, which delayed them all a bit. And it was a policy inquiry to create a practical plan to deal with Victoria's broken mental health system. It was very future focused and a system-wide review to improve mental health outcomes. And there were 4 Royal Commissioners, Penny Armitage, a senior public servant, Professor Alan Fells, a famous economist, Dr. Alex Cockram, a psychiatrist, and my former supervisor, Professor Bernadette McSherry, a legal academic. And it was very extensive, 12,500 contributions from consultations, focus groups, roundtables and public hearings. And the final report contains 65 recommendations, in addition to 9 recommendations in its interim report, and there were no split recommendations. And interestingly, perhaps ironically, the first recommendation in the interim report was for the creation of the Victorian Collaborative Centre for Mental Health and Wellbeing, which is where I've just started work. Now, I couldn't find a lot of information about the cost of the Royal Commission, but in the letters patent, I did find the figure of 13.6 million. So the Aged Care Commission, it went from the 8th of October 2018 to the 26th of February. And the impetus for that was the Oakton scandal and Senate inquiry into elder abuse. And it was also a policy inquiry on the future of the aged care sector and how best to provide services for people, particularly with dementia, and really looking at providing care in the home as well as residential, because most people prefer to be cared for at home. And there were 3 Royal Commissioners, but not all at the same time. So Richard Tracy AM, a former judge, was the chair, and there was also Linnell Briggs, a senior public servant, and they produced the interim report. But unfortunately, Richard died and he was replaced by Tony Pagoni KC, former judge. And there were 12,574 public submissions, surveys, 600 witnesses and 99 sitting days. The final report had 148 recommendations, and there were some split recommendations where the commissioners disagreed, mostly about the structure of aged care. So Tony Pagoni really liked the idea of creating some kind of independent statutory body to take charge of aged care, some kind of aged care commission. And Linnell Briggs, perhaps being a public servant, said no, aged care really needs to stay held very closely within government and within cabinet. And we don't really want it to be in some sort of independent body. And the cost of the Royal Commission was 104.3 million over 4 years. The Disability Commission was absolutely gargantuan. And it went from the 4th of April 2019 to the 2nd of November 2023. And it really came about because of very significant lobbying by the disability community. And it was different to the other commissions because it was appointed by the Commonwealth and all states and territories. So it was truly a national Royal Commission. And it was a bit different because the terms of reference were developed by persons with disability. And it had a very broad focus. Best practice in preventing and responding to violence, abuse, neglect and exploitation of persons with disabilities in all settings and contexts, and promoting an inclusive society. So when we're talking about all settings, we're really talking about everything. So, healthcare, education, employment, corrections and prisons, accommodation, group homes and the NDIS. So very, very extensive. And there were, I think, around 6 Royal Commissioners. So we had Ronald Sackville, AOKC, a former judge who was the chair, Barbara Bennett, a public servant, Dr. Rhonda Galbally, AC, who's a person with lived experience and an advocate, Dr. Alistair McEwen, a person with lived experience and advocate and the Disability Discrimination Commissioner, Andrea Mason, an Indigenous woman and expert in Indigenous affairs, and Frances Ryan AM, a former Member of Parliament. And it was also very extensive. So there were 7,944 submissions, 34 public hearing days, 154 hearing days, 837 witnesses, and 700 engagement activities. And the Commission really also tried to reach people with disabilities who wouldn't normally participate in something like a Royal Commission. So they made a lot of efforts to really reach out and include people in the Commission. The final report contained 222 recommendations, and some of them were split where the commissioners disagreed. I'll talk a bit more about where some of those splits were in a moment. And it is the most expensive Royal Commission that Australia has ever had, at around 600 million. So there were 7 common themes that I discovered as I was reviewing it. And the first was just generally difficulty accessing services and supports. And that was particularly so, with accessing a very fragmented mental health system, trying to access the aged care system, whereas the Disability Commission was looking at more broadly in terms of difficulties accessing society. They all reported that there was a lack of choice and control and absence of consumer voice in all sectors. And negative social attitudes and discrimination was an issue across all sectors. They were all concerned about the overuse of restrictive practices such as seclusion and restraint. They all reported problems with a very undertrained and underpaid workforce and overlapping workforce in many respects. So you can have some issues if you try to change conditions in one sector, it affects the availability of different people in different sectors. So you need to think of them together. And that there were a lot of problems with oversights and complaints processes. And something that just went across all sectors was chronic underfunding, not surprisingly. Okay, so I thought I'd focus on 2. So in terms of the 7, I've got a 12,000 word paper that deals with those in a lot more detail, and that's going through the publication process. So keep an eye out for that one. But as I said, I'm just going to focus on 2. So negative social attitudes and discrimination. Well, the Mental Health Commission said that negative social attitudes and discrimination were ever present, and they were particularly even worse where people from disadvantaged groups faced additional barriers. And the problem really with negative social attitudes and discrimination was that it really drove the other problem of chronic underfunding and lack of investment in the system. So all of the 7 themes that I found are all interrelated. The Aged Care Commission said there was actually a lot of ageism in Australian society, that there was very much a one-size-fits-all system that wasn't suitable for people with diverse backgrounds. And they particularly pointed out issues around people with disability in aged care who can't access the NDIS and the more generous supports in the NDIS if they became available after age 60, became disabled after age 65. And I've just included this quote because I just thought it was very interesting because it thought about old age in a way that I hadn't really thought about it. And that was that attitudes and assumptions about older people and aged care can affect the delivery of aged care. Assumptions about the natural process of ageing may contribute to a lack of attention to prevention and reablement. When it comes to improving health, some conditions such as back pain or feelings of depression may be put down to old age. And I guess when I read that, it really struck me because I thought how many of us haven't heard, our parents or grandparents or people just saying, look, I'm just old. And I think the Royal Commission really challenges us to look at that more closely and to think, well, is it that we're just old, or is it that people aren't getting the assistance that they actually need? And they were particularly concerned about or pointed out that, a lot of allied health services, the usage of older people of those is very low compared to the rest of the population. So there's certainly more scope for people to get a lot more assistance through allied health as they get older to help them with prevention and reablement. And the Disability Commission was probably the most concerned, very, very concerned about the effect of ableism and really saw ableism and discrimination as driving violence, abuse, neglect and exploitation. and saw overcoming negative social attitudes and discrimination as imperative to really create an inclusive Australian society. Okay, so recommendations. So they all had, different sort of recommendations and approaches about what to do about negative social attitudes and discrimination. The Mental Health Commission said that a priority should be the building of mentally healthy workplaces free from stigma and discrimination, and decided that the mental health and wellbeing should have a job of designing and implementing, anti-stigma programs and addressing systemic discrimination. The Aged Care Commission said that rights to non-discriminatory and equitable care should be included in the new Aged Care Act, that there should be a focus on creating age-friendly communities, and an annual parliamentary reporting on people with disabilities in aged care who can't access supports that are equivalent to what they would get under the NDIS. The Disability Commission had some split recommendations about this. So there were some different split recommendations between commissioners disagreeing about really whether segregation was ever acceptable. Is it ever acceptable to have, special schools, to have special disability employment or group homes or so forth? So there were different recommendations in relation to those. They also really had an approach to dealing with this, which was very comprehensive and perhaps even a little bureaucratic. So they definitely thought there should be a new Disability Rights Act, and that the Disability Discrimination Act should be strengthened in many respects. And they also thought there should be a new National Disability Commission, a Minister for Disability Inclusion, and a new Department of Disability Equality and Inclusion, and that there should be, a general duty on employers and others to really proactively prevent disability discrimination, perhaps a bit like what happens with, sexual harassment now, and so that individuals don't have to keep bringing claims. And the whole system doesn't rely on that. So moving on to the overuse of restrictive practices. So when I'm talking about restrictive practices, I'm talking about practices that have the effect of restricting a person's movement or decision making, such as seclusion, so putting people in a locked room, physical restraint, holding them down, mechanical restraint using things like handcuffs, chemical restraint using drugs to subdue people's behaviour, emotional restraint where people feel they can't speak up, and perhaps even things that we don't necessarily normally think of as being restrictive, like putting an older person in a deep chair they can't get out of, or, putting a tray table over a bed, those sorts of things. But, there's no national definition, and the reports really noted that there was a lot of inconsistency between jurisdictions and sectors. But it was widely agreed that restrictive practices are overused and that stronger regulation is required. And it was widely agreed across the three reports that restrictive practices are physically and psychologically harmful. They often don't work, and they can make challenging behaviour worse. And they all noted that chemical restraint is the most used. Doctors prefer to use that, but it's also the least well-regulated form of restraint. And they pointed out that restrictive practices use can often be driven by systemic factors, like, when people are in old and crumbling facilities, that affects the whole mood and people's behaviour. And if there's not enough staff, or staff are poorly trained. And they also pointed out that restrictive practices aren't regulated at all in some settings like education, even though they are used, which I think is quite disturbing. So they all had different recommendations, and in this report, in this respect, I think mental health was really the toughest. So they said, look, seclusion, restrictive practices are bad and they need to be immediately reduced. And they had a very ambitious goal of elimination within 10 years. They said there should be a new Mental Health and Wellbeing Act designed to measure and reduce rates of compulsory treatment, seclusion and restraint, and to regulate chemical restraint for the first time. and that there should be new bodies to create proactive strategies towards reduction and elimination of restrictive practices, and stronger oversight by the Mental Health and Wellbeing Commission. In aged care, the concern really of the commissioners was more so that restrictive practices are properly justified and authorised. They weren't as concerned at all really about reduction or elimination. They said they should only be used based on independent expert assessment and a behaviour support plan. And they said they should otherwise be prohibited except in emergencies, where they should be used in a way that's strictly limited. So it should be the last resort. It should be proportionate for the shortest time, ongoing monitoring and informed consent. And that chemical restraint should be specified as such on a doctor's prescription, and that psychotropic medications should only be prescribed by a psychiatrist or a geriatrician, so not by a GP. They then just deferred to the Disability Commission and said, well, we agree with whatever they say, because we want there to be equality across the aged care and disability sector. So the Disability Commission sort of happened slightly later and went for a bit longer, and they had the benefit of looking at the Mental Health Commission report and the aged care report, and they were sort of able to cherry pick from it the things that they liked. So the first thing they said was that restrictive practices should only be used with appropriate legal frameworks, and as a last resort, it should be proportionate for the shortest possible time, and there should be ongoing monitoring and so on. And they also talked about, drawing on the aged care, the creation of a senior practitioner to approve behaviour support plans, provide advice, oversight and investigation. Although I don't really like the senior practitioner to have all those powers, I think they should just have the ability to approve and provide behaviour support plans and provide advice, and that the oversight and investigation should actually belong to a separate body, which is pretty much the kind of structure that was used by the Mental Health Commission. They also did a very, very comprehensive review of all legislation across all jurisdictions in Australia, and they also looked across each of the different sectors as well, mental health, aged care and disability. And they said, look, in some of these jurisdictions, some forms of restrictive practices are just outlawed completely. And they said, well, you know what, if it's outlawed somewhere, it should be outlawed everywhere. And so they've actually created quite a long list of things that should just never be used anywhere. So they've talked about, particular kinds of cuffs and holds, solitary confinement of children and young people should never be used. It's quite a long list of different things that are banned or should be banned. And they then wanted the idea of development of more of an evidence base about use of restrictive practices, and they liked the approach of the Mental Health Commission. So they wanted targets and performance indicators to drive down restrictive practices. So then I thought I'd talk a bit about the government response very briefly. So look, there was some action in relation to all of the Commission's interim reports and their COVID recommendations while the Commissions were still operating. Most action has been taken to implement the Aged Care Commission, I think, and that's because it really reflected the agenda of the Albanese government's first term. They, ran on the idea of fixing aged care, and they have put a lot of attention, given it a lot of attention. So they've probably implemented about 60 of the recommendations, and they have also especially did in relation to restrictive practices. And there's been numerous pieces of legislation, including a new Aged Care Act 2024, which was passed at the end of last year and which comes into effect July this year. The Victorian government was a little bit different compared to other commissions, because it said at the outset, we're going to actually implement all of the recommendations of the Mental Health Commission. Whatever they come up with, we're going to implement it. And they have implemented the new Mental Health and Wellbeing Act 2022 in Victoria. But look, there's been a lot of concerns that there's been delays and that maybe the government's actually quietly shelving some of those recommendations. Although I can say in my new role that there's also a lot of work going on behind the scenes on those recommendations. The government's response to the Disability Commission has been widely considered to be disappointing. Out of the 222 recommendations, only 13 were fully accepted or accepted in principle, and 130 recommendations were committed to consideration. So while the implementation of the Royal Commissions is a bit of a mixed bag so far, and the truth should be told that, most Royal Commission recommendations, they're not always implemented anyway. But I think these Royal Commissions are really very important for all three sectors, and that they're going to be a focus of ongoing advocacy and law and policy reform. Thank you. So time for Anna.
Thank you, Anna.
So I'll stop sharing my screen.
Excellent. Thank you. That was wonderful. Thank you. So informative, Kay. So now we're over to Anna Arstein-Kerslake. Thanks, Anna.
Yeah, so thank you so much, Kay. That was a brilliant presentation on those really topical three commissions, and thanks Paula as well for organizing this, and for Helen more broadly for organizing these types of seminars. I thought what would be perhaps interesting, following on from Kay's presentation, is a bit of a look at how the right to autonomy is developing internationally. And I thought that was maybe an interesting thing to focus on, because a lot of, as Kay pointed out, a lot of what's coming out of domestic commissions, domestic inquiries, domestic law reform is actually really aligned with how the right to autonomy is developing internationally. And that's true maybe particularly in Australia, but also in other jurisdictions as well. And I think that sort of understanding this global context can help us sort of guide the way we would implement the recommendations that Kay discussed as well. Because they provide broad principles, and I think they also give a sort of gravitas, if you will, to these sort of choice and control reform elements. So I just wanted to start with actually the UN Convention on the Elimination of Discrimination Against Women, because I think, and many other scholars as well think, that that's actually where we saw some of the most important developments in the space of the right to autonomy. And I should clarify too that the right to autonomy sort of isn't like a right that just sits in the Universal Declaration of Human Rights or something and everybody knows where it is and there's like text for it. Instead, it's a right that has been developed through a number of other rights. And in order to really understand it, you have to look at what those other rights are and what they're saying about autonomy in these particular areas. So I think one of the most important developments was the right to legal capacity in the Convention on the Elimination of Discrimination Against Women, Article 15. And if you read Article 15, it's sort of quite confusing and not very clear. And there's a whole bunch of history behind that in terms of the negotiation of the treaty. But the important thing that was solidified in Article 15 of CEDAW is that there is a right to legal capacity, and it includes both standing and agency. And in particular, that agency component really is where we can solidly root a right to autonomy within the human rights framework. And that's really powerful, because stemming from that is how we get all these various other rights, which essentially are where a lot of the recommendations that Kay discussed, if you sort of read between the lines, a lot of the principles of those recommendations are actually stemming from some of these core rights. And I think we will continue to see similar recommendations in jurisdictions around the world that are perhaps intentionally or unintentionally, maybe just coincidentally, because this is where the world is going, but seeking to support a right to autonomy and realize a right to autonomy for everyone in these particular areas. So we had that right to legal capacity, and then the subsidiary right to legal agency in CEDAW, and then perhaps more importantly, in the Convention on the Rights of Persons with Disabilities, several decades later, we saw more detail to the right to legal capacity, also more detail to the right to liberty, and then a new description of a right to live in the community. I think these core rights, legal capacity, liberty, and live in the community, together are what form perhaps the right to autonomy as we understand it today. And I think the other thing to highlight, and Kay's presentation did this as well, that this isn't just disabled people that we're talking about here. Of course, all human rights are universal, but more than that, from an international law perspective, more important than an international law perspective, is that the right to autonomy is clearly important for everyone, not just disabled people, and equality in how we implement rights is critical in order to have consistency, equality across our societies as well. But importantly, it is the Convention on the Rights of Persons with Disabilities that's provided the most detail, I think, on the right to autonomy. So it's something we can draw on in terms of how we're implementing a right to autonomy for all groups. So I'll go over with a bit more detail on some of these rights. And I think you'll start to see quite naturally how these fit in with all the recommendations in particular that Kay mentioned. So here is a slide about the right to legal capacity, its meaning and interpretation. The main tools for interpretation of the right to legal capacity, at least at the international level, is, of course, the text of the CRPD, of the convention, the general comment from the CRPD committee, which is considered an authoritative interpretation of the text, and then the committee's concluding reports and decisions on individual complaints that come to it. Those are the core tools for interpretation at an international legal level. And what they essentially say, of course, there's a lot of more substance to this, and many scholars have written on this, myself included. But summarizing them is that, like I said before, legal capacity includes agency and standing. And it's that agency piece that really helps us develop this right to autonomy. It also has interpreted the right to legal capacity to mean that you can't deny legal capacity on the basis of disability. And because rights are universal, that inherently also must mean that you can't deny legal capacity on the basis of any other protected status, which age would be included there. The other critical elements is that there's a state obligation to provide support for the exercise of legal capacity. Now, I think many people thought this was relatively innocuous when it was drafted, and even when it was being, and even when it was being read and ratified in various jurisdictions. However, in many ways, this is the most progressive element of the right to legal. And what it has been interpreted to mean is that supported decision-making must replace substituted decision-making. Now, don't get too scared. That doesn't necessarily mean we'll never need a representative to make decisions on behalf of another legal entity or person. That will be the case because there will be times that we cannot figure out what the will and preference of that person is. But what the right to legal capacity is asking for is that instead of, as our systems do now, denying legal capacity, putting a representative in that acts on the best interests of that original person whose legal capacity is denied, instead of doing that, which is a really negative, anti-empowering, really violation of a right to autonomy, instead of doing that, the UNCRPD committee has interpreted Article 12 of which is where we find the right to legal capacity, to require that anytime you're providing either support for the exercise of legal capacity, and even when that support is rising to the level of a representative acting on behalf of an individual, that representative must, that support person or representative must act based on their best interpretation of the will and preference of the individual. And you can see how that is so critical to a right to autonomy. So there's no way we can say a best interest paradigm is supporting a right to autonomy. A will and preference paradigm is basically the essence of autonomy, right? We're saying leave that autonomy with the individual and let's figure out what their will and preference is and how we can implement that. So these developments in international law were absolutely key. And I think it's really interesting how we can see the threads of those coming through all the recommendations that Kay discussed. What I wanted to cover now, only briefly, is how interdependent these three rights that I'm discussing today are. I think that the right to legal capacity is the foundational right for the right to autonomy. And I think that because if you don't have your right to legal capacity recognized, so if you're not recognized as a legal entity with standing and agency, then your right to liberty and your right to live in the community are automatically compromised because you're not recognized as a legal entity with the right to make those choices, essentially. So I think it's, you know, you could almost have a right to legal capacity and say that actually the right to liberty and right to live in the community are just encompassed within the right to legal capacity. The reason I think it's important to articulate separately a right to liberty and a right to live in the community is because there's so many unique issues that arise in that space. But I think the core of the right that attaches to the individual is actually essentially the right to legal capacity, which is the right to make your own decisions. So I think I won't get too much further into that, but I hope that this sort of signals for you what the implications are in terms of the content of a right to liberty and a content of the right to live in the community. What we're really challenging states to do is ensure that all individuals, regardless of group membership as a disabled person or an older person, have the right, the recognized right and the recognized standing and agency as a legal entity to choose where they live, what medications they receive, what medical treatment they receive, what mental health treatment they receive, where they receive that treatment. You can see how all of these are interconnected. And again, how all of these themes, while they are international law, I think you can really see how they're already threading through domestically in the recommendations that Kay outlined. So, and again, I think the implications of the right to legal capacity, which is what this next slide is about, are really evident in the recommendations that Kay outlined, and I've just highlighted some of them here, where significant law reform is needed. And I think it was really interesting what Kay said at the end of her presentation when she went through, you know, what recommendations have been adopted and which haven't, and where there are some quite reasonable and serious concerns about those recommendations being adopted. And I think some of those you can see are where we're really being challenged as a society, as a socio-legal structure, to take a long, hard look at how we have operated up to this point in particular areas and what that means. And there's a lot of resistance when there are significant resource implications, I think, and where the practices of some core professions are being challenged, like psychiatrists, aged care providers, medical practitioners, mental health professionals. So here's a list of just where significant law reform is needed, and also probably maybe the 4 core areas that are going to be perhaps the most difficult to get sustained and substantial overhaul to really realize the right to autonomy. Those areas are mental health law, and those have implications for the rights to legal capacity and liberty, but actually I didn't list it there, but probably also the right to live in the community. The other areas, guardianship, interdiction, substituted decision-making, again, implicating legal capacity, liberty, and the right to live in the community. Contract law, so making sure that our contract law recognizes the right of everyone, regardless of gender, regardless of disability, regardless of age, to engage equally in contracts for example, real estate contracts, employment contracts. I mean, contract law is basically the platform for engaging in society in many ways. And then the last one is criminal law, which implicates the right to legal capacity and liberty, both in the context of, I mean, not both, but for example, in the context of unfitness to plead law, in the context of how our court systems and our police engage with populations such as disabled people, disabled women in particular, and older people, and how we can ensure that the way the criminal system is engaging with those groups, or with all people as well, is truly respecting their right to autonomy, listening to their voice, implementing their voices, etc. I just wanted to wrap up with reform examples, and these are just a couple, or a few. And there's so many more, but I wanted to just highlight these ones to highlight that reform is very possible. It's not a perfect process, I think almost ever, but that substantial and transformative reform isn't possible. So one of the best examples, I think, is Peru, who undertook a complete overhaul of their civil code. Of course, Peru is a civil law legal system, which is different than our common law legal system. So a lot of change can happen with just reform of the civil code, whereas ours is a bit more piecemeal. But I think the fact that that occurred in such a sweeping way is a significant accomplishment, and something that we should look towards internationally as an example of the possibilities of reform towards the right to autonomy. And a lot of what they did is implementing a lot of the recommendations that Kay outlined as well. The other one is Ireland's Assisted Decision-Making Act. So far from perfect. And that's why I've put on this slide that it's just reform that's underway, because I don't want to hold these out as necessarily best practice. I want to highlight them as areas or jurisdictions where reform has occurred, and we can learn from it. So the Assisted Decision-Making Act, the criticism is that they've held on to functional tests of capacity, and essentially it's holding on to a test of decision-making skills that in practice is going to deny legal capacity on the basis of disability in many cases. That being said, I was involved in that reform process. It was an amazing coalition of people working towards this act, and now there's an amazing group of people working towards meaningful implementation of the act to maximize the right to autonomy. Again, not a perfect act. I'm not holding the act up as the best practice, but I just want to highlight it as a reform process that has occurred. Spain, perhaps slightly better outcome in terms of upholding a right to autonomy, although not perfect. Again, in Spain, similar to Peru, there was essentially a complete overhaul of their civil code, and legal capacity rights were changed across 300 different areas of the civil code. It's a huge accomplishment, and all three of these jurisdictions are doing a lot of work now on implementation. But I highlight them because a lot of what they have achieved in these countries would secure the outcomes sought in the recommendations that Kay outlined. So I think moving forward, it's just a really exciting time actually to be working in this space, to be focusing on choice and control, and in how the state regulates choice and control for all of us, disabled people, older people, and other groups as well. And I think having seminars like this and continuing these conversations is critical for ensuring that these processes, don't turn into reports that sit on a table, or lots of promises made by people that don't get implemented. But I think we're far from that actually, because I feel like the mood internationally and domestically is towards a right to autonomy. And I think we saw that from Kay's presentation as well. Those were the core things that I wanted to highlight today. Happy to answer any questions, both today in the seminar, and if anybody has any questions beyond that, I'm happy to answer via email or any other way. Thank you so much.
Thank you. Thank you, Anna, very much. That's wonderful. And thanks for that kind offer to continue speaking to people. I'd like to, very, very warmly thank Anna and Kay for fantastic presentations and, coming at disability from quite different perspectives, but really beautifully overlapping and speaking to each other. So thank you both very much. I feel like I learned a huge amount. I'm sure others on the Zoom call did as well. So we thank you very much for putting in the time today to present. We will, if anybody is not on the Helen mailing list and would like to join, we've just popped a little link in the chat, and the recording of today's presentations will be on the Helen website shortly. And what we also do is we put some other resources related to the topic on the website as well. So we'll put some things from Kay and Anna, and we'll also try and link to that MDI presentation as well, Kay, that you mentioned, because it sounds like it's very pertinent to what we've talked about today. So thank you everyone for joining us, and we'll be back next month for the Helen seminar. We'll be sending details shortly. Thanks everyone. Bye-bye.